several years as there's been some policy changes. And most recently during the COVID pandemic, wherein there's been quite a few restrictions put in place for foreign nationals to enter the United States. I'd like to highlight what Suzanne said throughout this presentation. I'm really happy to field questions as they arise. I think probably the most productive way to get our points across is to be sure that all questions are answered. So I'd hope that no one is too shy to ask a question, and feel free to interrupt me at any time if there's something that needs to be clarified. So as Suzanne mentioned, my practice is focused exclusively on US immigration law. We represent a variety of different clients, but if you were to divide it into two big distinctions, it's representing companies that are moving their employees to the United States, and the other piece is representing individuals that are coming to the United States based on a family immigration benefit. These days, I would say most of the work that we do through the firm focuses on the business side, representing companies moving their employees as well as investors to the United States. We continue to do family-based immigration, and we also do some humanitarian work, some of the more rewarding work, helping asylees and refugees find refuge in the United States. Today, much of my comments will focus on business immigration and talk about some of the limitations due to COVID and what some of our expectations are coming from a recent election that we had here in the United States that I think everyone has probably heard about. So I'm going to flip through my slides as needed and talk about US immigration. So I'd like to start off with why the United States. The United States still remains a destination country for many individuals throughout the world for a variety of different reasons. From a business standpoint, the business opportunities in the United States, of course, remain very high. We have a country in which there has always been predictability for the business environment, a openness towards foreign nationals, and an openness towards entrepreneurs coming here. So the United States, of course, still remains, and I hope will always remain, a place that foreign nationals wish to either come temporarily to work or to come on a more long-term basis. However, what I can say, if I can just flip through my slides here, over the last 4 years, there have been, immigration has been in the media quite a bit. And I set forth on this particular slide some of the big headlines that really seem to limit those coming to the United States. And over the past several years, there have been a lot of limitations that have been placed on the US immigration system that we've had to work around. Much of those come by way of policies from the executive branch. These are some of the headlines, certainly not all, but the point I want to make is that over the last few years, there's been a lot of discussion about immigration in the United States and how our system moves forward. There has not been change to the underlying law. Although there have been changes to a lot of policies, the Immigration and Nationality Act that has been in place for many, many years, for the most part, has not been changed, but policies coming out of the executive branch by way of executive order, et cetera, have had a pretty significant impact. Immigration has been a big part of the news over the years. So then the question becomes, is the door to the United States still open in light of all that people hear in the media? And I think there is a resounding yes, the door to the United States remains open. And that for which the founders of this nation in developing our Constitution and its and its approach to immigrants and the general culture of the United States as depicted by the Statue of Liberty sitting in New York Harbor and the inscription on the bottom of the Statue of Liberty, I think still remains in play. However, the complexity of the system is quite different. And we, as a firm, continue to deal with the complexity and assure that the door is still open for those that wish to come here and that are working lawfully to come to the United States and go through the necessary steps. Is the system complicated? I assure you it is. It's a very complicated system, the United States immigration system. I can also say that something within the last several months has made it a lot more complicated, and that is COVID-19, the global pandemic that we're all feeling the effect of, and also some of the policies that came out during the current presidential administration. COVID-19 has been something that we as a firm and I as a advisor to global companies and individuals all over the world have really spent a lot of time thinking about and working with. Since March 2020, it has been the core focus of our practice in helping foreign nationals enter the US. As you are probably all aware, there have been a series of presidential proclamations that have been released since March, many of which impact our clients in Austria directly, and many focusing both on immigrants and non-immigrants. When I say immigrants, those with green cards or getting green cards, and those that are in the process of coming to the United States as visitors for business or coming here temporarily as temporary workers. One of the presidential proclamations that I think has had a dramatic effect is the bar on entry to the United States of anyone that has been in one of the Schengen territory countries within the last 14 days before seeking admission to the United States. That has created a very significant logistical problem for those wishing to come to the United States that have a connection to the United States. And fortunately, over the last few months, that proclamation, although still in effect, there are some exceptions to it, and we've successfully worked with many clients in seeking an exemption to that particular proclamation. There are other proclamations that have been put into effect that impact the admission to the United States of temporary workers. And there are also exceptions that have been created by our federal agency, Department of State, that allow for exceptions to that so a foreign national may enter. I will talk about those more as we go through the presentation, but the second point here regarding what's pertinent these days is the presidential election. As I stated early on, and as everyone knows, this past weekend, there was an announcement after the election day that President-elect Joe Biden had received the number of electoral votes to make him the incoming president-elect. And there is still, as you know from the media, a lot of concern by the current administration regarding vote counting, and there is an ongoing, I guess, dispute right now going on and court action in the US regarding that. That's not part of this conversation. I want to really kind of focus on what will happen if there is a new president come January 2021. And there are some policies that have been released by Joe Biden and his incoming administration that talk about US immigration and his plans. I certainly would welcome everyone to read that. It's a 25-page document that was placed on his website that addresses some of the issues that he feels are most important to our nation. So I will go through some of those as we further discuss these issues. So um, not only has COVID created complexity and our election and potentially some change in policy, but our system has always been quite complicated. I like to use this cartoon in some of my presentations, and I always, I tell folks, what part of legal immigration don't you understand? This is not what so many people say, well, it's just a matter of filing some forms and getting the appropriate visa in my passport and I'll be there and I could start working, or I can make an investment, or I can live with my family. The reality is our system is quite complicated, and there is a bureaucracy that has to be dealt with, and a rather forgiving system in which if something is filed wrong or there's an error, it creates lots of delay, the potential for denial, and the system is really one that's complicated. This cartoon is just a highlight of that. And we have found that so many of our clients become somewhat scared of the system here, and how complicated it is. But we've spent, oh gosh, the last 20 years helping people walk through this rather complicated system. So let's make some key distinctions on the front end. You're going to hear me talking about what are legal permanent residents, United States citizens, and non-immigrants. These are all very different terms and give the foreign national a very different benefit. A non-immigrant is someone that's coming to the United States for a short period of time for a very defined period. The most common one is someone that's coming to the United States as a visitor for pleasure, maybe coming here to visit family, friends, just to go tourism, to check out the nice sights in the US or take a vacation. Or maybe a non-immigrant is coming to the United States to be a student. They're going to study at one of the fine academic institutions in the United States. Or maybe a non-immigrant is coming here for a short duration to work in the United States, maybe as someone in a specialty occupation, a technology worker, someone involved in the healthcare field, someone involved in engineering, mathematics, technology, you name it. There's a lot of different industries for which attract foreign workers to the US. Maybe an athlete coming here to compete in a professional sporting event. These are all non-immigrants. What defines a non-immigrant? A person doesn't have intent to stay in the United States and live and make the United States their home indefinitely. If one has that intent in mind to make the United States their home indefinitely and live and work here, then they need to get what's called legal permanent resident status. A legal permanent resident is synonymous with a green card holder. This is an individual that's here to make the United States their home. They get their legal permanent resident status in a variety of different ways, one of which is through an employer that's tested the US job market and offered a job to the individual for which they get a green card after concluding that there are no qualified US workers to fill that position in the US. Another way to become a legal permanent resident is to be sponsored by a family member that is already in the United States as a legal permanent resident or as a United States citizen. And finally, there is a pathway to legal permanent resident status through the humanitarian ways, including coming to the United States as a refugee or coming to the United States and seeking asylum status in the United States after having proven that that person suffered persecution in their home country. And last but not least, Congress has a program in place called the Diversity Visa Lottery System, wherein individuals can apply for legal permanent resident status based upon their country of origin and Congress's definition of the number of individuals that should be coming from that country to create diversity in our country here in the United States, the Diversity Visa Lottery. And that has been in the news quite a bit over the last several years. Finally, a distinction that needs to be made is United States citizens. A United States citizen is a person that was born in the United States, maybe born abroad to a United States citizen parent, or one that has come to the United States, become a legal permanent resident, remained a legal permanent resident for a statutory period of either 3 or 5 years, and then sought a process called naturalization, wherein they sought to become a US citizen. So those are the three key distinctions that I will be talking about as we go through this presentation, and that I think are important to note. So much of what has been going on over the last 3 years has been focused on some of the non-immigrants coming to the United States, particularly those coming to the United States to work in the United States, maybe a specialty occupation worker, a software developer, maybe a executive coming from a foreign company that has a subsidiary in the United States, or maybe even an investor to the United States that wants to start a business. Back in the early days, there was an executive, back in the early days of the current presidential administration, there was an executive order that was put out by the administration called Buy American, Hire American. And I set forth some of the key terms of that. But what that really did back in April 2017 was set the stage for an overarching policy wherein immigration policies should focus around the interests of United States workers while considering the administration of the immigration system. So many of the things that we have been doing over the years is really showing how the impact of some of the visa applications and petitions that we file for workers coming to the US do have a positive interest on our nation. And we always try to focus on how a foreign national's work in the US is going to probably create more jobs for US workers, so to be most successful in the petitions that we file. But this has been an overarching issue that we've had to deal with over the last several years. This has come more into play during the COVID pandemic because some of the proclamations that have come out of the administration have the purpose of protecting the US job market. As you are aware, due to the COVID pandemic and the national shutdown that took place back in the early days of the pandemic, it has had an impact on jobs. And there has been a reduction of those that could come into the United States to help protect the US job market. Here's a slide to kind of give a broad picture of what we do every day as an immigration law practice. Most of what we're doing is focused on some of the highlighted pieces here, helping foreign nationals get those non-immigrant visas to come to the United States, whether it's one of my high-tech clients that are bringing engineers to the United States, whether it's one of my athlete clients that are coming to the United States to compete, whether it's one of my medical clients that are bringing foreign trained doctors to the United States to train in the United States, or whether it's one of my academic institutions that are working with global students to bring them here so that they may partake in academic training in the US. These are all temporary non-immigrant visas, and we help the institutions, the organizations, and the individuals come to the United States. Additionally, we work with those that wish to remain in the United States permanently and getting those green cards to remain in the United States once they're here as once they're here as non-immigrants. Of course, we work with the countless US embassies and consular posts throughout the world for individuals that are getting their non-immigrant benefit or immigrant benefit before the consular post, and these days working with those consular posts for some of these national interest exemptions to the current proclamations that are in play. So what are some of the government agencies that we deal with on a daily basis and that our clients need to interact with? First and foremost is United States Department of Homeland Security and the various sub-agencies within that agency. United States Citizenship and Immigration Services. These are the folks that accept the applications and petitions, and they adjudicate those applications and petitions. Immigration and Customs Enforcement also falls within DHS. These are the folks that you see at the border that are enforcing our immigration laws at the border and also within the United States. Additionally, Customs and Border Protection, again, the folks that you see at the border that are admitting people to the United States. And finally, the Transportation Security Administration that in part assures the safety and well-functioning of our airports throughout the United States. You see these folks when you're transiting through US airports. This is an agency that we deal with US Department of Homeland Security on a daily basis for all the applications that we file, and of course, for those that are being admitted at our borders. Of course, we also deal with United States Department of State. Very important, because once a petition or an application is filed by an employer, that foreign national in their home country needs to get a visa to come to the United States. And there's only one place where you can get a visa, and that is before one of the US embassies or consulates throughout the world. So we deal with the consular posts very often, and these days, because of the proclamations that are in play limiting the entry, many of the national interest exemptions that we file for are filed directly with the US consular posts. You're very fortunate to be within the jurisdiction of the US Embassy in Austria. This has been a very fine consular post to work with, one that has an ease of communication and a wait period for interviews that is quite low compared to some of the other posts in the world. We find it to be a pleasure to work with them, and we've been working with that consular post for some years now, and for our Austrian clients, and it's always a pleasure to work with them. Finally, the third federal agency that we often deal with is Department of Labor. Department of Labor is involved in a variety of different immigration benefits, particularly where the US job market needs to be tested by an employer before they could bring a foreign national to the US. The testing is to determine that there are no qualified US workers, or to determine what wage must be paid to a temporary worker in the United States. This is Department of Labor. So the point of me touching on each of these agencies and giving a very, very brief overview is the point that I'd like to show is that there's a variety of agencies that have to be dealt with, and that creates time restrictions and bureaucracy and planning ahead. None of these processes of getting someone to the United States goes quickly. When you have to interact with this many different agencies and there's this many steps in the process, it becomes very time consuming. And there are processing delays at each of these agencies. And COVID has not made that any better. Back when the pandemic was at its height in the spring, many of the agencies went into a reduced mode where they were not processing applications as quickly due to the health and safety of the workers. US consulates abroad were closed, but for urgent American citizen services and urgent matters surrounding visa issuance. Fortunately, everyone is back to work now, but I can say that things are still progressing forward quite slowly. What used to take weeks is sometimes now taking months. So the process is quite different, and I advise all of my clients to really plan ahead due to the timeframes associated with getting these benefits from these agencies. The timeframes have really expanded. The wait period is longer. Just getting a response oftentimes takes a lot more time. So please, if you're thinking about sending an employee to the United States, or you're thinking of making an investment and wishing to gain an immigration benefit in the United States, plan ahead. What could have been a process where we were involved together in filing the appropriate documents in a month's time and maybe getting a receipt notice is now taking a lot longer. Again, talking about the complexity, this is Department of Homeland Security, the agency that has USCIS and the TSA and CBP and ICE. It is a very, very large organization. And with large organizations, you can imagine it takes time to work through the bureaucracy, and even more so these days with the COVID pandemic. Where does our law come from for US immigration? It comes from, it's federal law. Starts with the Constitution, works through treaties and statutes and regulations, administrative decisions, and most importantly, these days, some of the policy statements and executive orders that come out of the executive branch. We spend a big chunk of our time interpreting that which comes from the executive branch to be able to translate what that means in practice. We are continually waking up to changes over the last several months due to COVID and during this administration as to policy changes to immigration and helping our clients work around that. But many people abroad ask me, well, isn't it based on the state where you're going to be working or immigrating to? And the answer is no. Immigration law is focused on federal law. So there's one set of federal law that controls throughout the United States. So regardless if you're sending a worker to work in the Silicon Valley of California, or you're sending a worker to work in the suburbs of Portland, Maine, the same set of law applies, and you're dealing with the same federal agencies. But really where the issue is these days is sorting through the policy statements and the changing policy surrounding the implementation of the federal law. And that's where we spend a lot of time in helping folks be successful through the nuances of the policies. So talking about some of the policies and the proclamations, COVID has created a good number of proclamations. The one impacting our clients in Austria pretty significantly is the one I mentioned early on, is the travel restriction for those that have been in the Schengen territory within the 15 days prior to seeking admission to the United States. Really quite restrictive. And it's still in play. I think it's going to be in play for some time. The COVID pandemic continues to grow in the United States, and I don't know what's going to happen with that. What comes from that when there is a presidential transition, I'm not sure how the Biden administration will handle that. I think a lot has to do with where things go with COVID. Currently, the restrictions remain in play. If you're thinking of coming to the United States for tourism, it's really kind of off the table right now. If you're thinking of coming to the United States as a visitor for business, and it can be clearly defined what the urgent business travel is, and it can be documented. There are means to get a national interest exemption, which is directly filed with the US consular section in Vienna. If there is a worker that has a visa to be a temporary worker in the United States, an H-1B worker or an L-1 worker, or an investor that has a business in the United States, there are exemptions to come to the United States that have to be worked through. Department of State has set forth on their website what the bases are for the exemptions. Those have to be outlined in a detailed explanation to the consular post with supporting documents. And a decision needs to be made by Department of State whether the exemption applies. There is also a ban currently on the issuance of immigrant visas, those folks getting a green card. So the days of being able to, once everything is taken care of in the US and the foreign national is ready to go for their interview to get that immigrant visa to enter the United States as a green card holder, there is a preclusion on those immigrant visas being issued unless there is an exemption. There are some exemptions for immigrants coming to the United States if they've been sponsored by a spouse that is a United States citizen, and a few other exemptions that are outlined by Department of State. But again, there needs to be an exemption filed for and attained before that individual can come into the United States. I've been doing a lot of speaking for the last probably 20 to 30 minutes. Are there any questions from the audience right now that I can field as we're going through this? I don't want to so much lecture at you but I'd love to answer any questions that arise. So at this point, are there any questions? Okay. Then let me continue forward with some of the presidential proclamations and also some of the clear exemptions. Talking about students, we represent quite a few academic institutions throughout the nation. And those academic institutions have a student population that oftentimes is in part foreign national students. There is a clear exemption in the rules for students to come to the United States. There's some details as to whether they've been in the US before these proclamations went into effect, but there are ways for students to come back to the United States and study, to pick up on their studies. There has to be a hybrid program where the student is not taking only online courses, but also some in-person courses as well. So for our academic institutions that we've been representing over the years, fortunately, they've had some way of pulling together an academic year. It is quite complicated right now with the increasing numbers of COVID prevalence that is going through the United States. I think you're all following the news, and much like other parts of the world, the COVID numbers continue to increase in the US, sadly. And I don't know where we're headed, so this has had an impact on the academic institutions. But fortunately, students can still enter if they meet certain definitions of what is an allowable type of study in the United States. For those that are coming under an investor visa, E2 visa, there are exemptions. So a lot of my Austrian clients before COVID were in the process of filing the appropriate documents so that they can make their investment in the US and run a business. Those folks are exempt. They can still come to the US and run a business, still have to go through the process of filing the appropriate documentation with the post in Vienna and await notice. And we have found the timeframes, again, in Austria have been a lot better than some of the timeframes for processing in other countries, but still it is doable, and there is an exemption for investors and their family members to come to the United States. If you're coming to the United States for a temporary business visit, maybe you are establishing a company in the US and you need to get here to negotiate a contract with a vendor, or you need to meet with a client. There is a way to overcome the exemption if it can be, if you can well document the basis for you coming here. I tell folks that beyond the exemptions to some of these presidential proclamations, it's important to keep the healthcare information in mind and look at where one is going into a particular state. I know this is not about immigration law, but really if you're entering a state that has a high prevalence of COVID, to consider your health when deciding to go to that place, and also think about the quarantine requirements associated with someone from abroad entering that state. The quarantine requirements are different for each state. That's state law. Right now, we're working with a company out of Ireland that's sending some workers to the United States temporarily to oversee some business operations that they have going on in the US, some senior level people. And we're assisting that company not only with the national interest exemption to get into the United States, but also with some of the COVID issues that are more state-based. It's actually here in the state of Maine, in working with our state government to make sure when those folks come into the state, they're adhering to the requirements of the state to be sure that they're not violating the quarantine requirements and the testing requirements if they're not going to quarantine. That is all state law, and that needs to be adhered to. And each state publishes those requirements on their websites, either through their local Department of Health or their local CDC. So that's very important to take a look at. What I have also found, folks, over the last several months is even if you can work through all of these proclamations and getting exemptions and dealing with the state requirements, we have found our clients struggle with getting air transportation to the United States. It's been very problematic during this period of time. What we've also found is that some of the airlines early on were not familiar with the exemptions to the proclamations. So they were giving some of our clients a difficult time in boarding aircraft to be able to come to the United States because of the bans to travel. They weren't exactly sure what all these exemptions were, what type of documents were required. I can't tell you the number of calls that we received from individuals that had problems boarding aircraft and having flights canceled and having to work through the process of rebooking due to all of these issues that arose. It was really, really complicated. Still remains complicated. In the early days of the pandemic, we had a significant number of foreign nationals that were in the United States on a temporary basis and had to leave by a date certain. And their passport was stamped with a date by which they needed to leave. And we had to file and seek ways to keep them here longer because they just couldn't get flights out of the United States. And there was a very complicated system that the government put in play so that these individuals can remain in the United States lawfully. And during that time that they couldn't get flights out of the United States. I don't know, I'm not one to predict the future, but as I watch the news every day and I see the numbers of COVID increasing throughout the world, I think there's going to be more and more restrictions on air travel. I have those issues again. So as you're working with your organizations and maybe thinking about sending folks to the US, not only keep in mind the presidential proclamations, the limitations of people coming to the US, but also keep in mind the airlines and how to get people here and how that's all going to work. It's a rather complicated situation right now. So,
Mr. Salvateri, may I just interrupt you just for a short time, because Kirsten Dietrich, she posed a question, and maybe Kirsten, if you ask Mr. Savatteri. Yeah,
with pleasure. Thank you. I'm interested in this particular element of your discussion because there really doesn't seem to be a good, reliable source, perhaps because the information continues to change and every day there's a new regulation or ruling for individuals trying to transfer or travel between the European Union, Vienna here in this case, and the United States. Do you know of any website or a source of information that is up to date and truly reliable? You know, for example, things like you have to have a PCR test to be able to travel to the US, or that's not required, but you must have certain paperwork and documentation if you are the close relative of a traveling family member. Any advice on that would be most welcome. Thank you.
Yeah, Kristen, really good question. As I sit here today, I have a stack of documents that talk about those issues. This is almost an inch thick, and another one here that kind of pulls together all of the things that you're speaking about. I can't say that there's one-stop shop to get all the information, unfortunately.
Mm-hmm.
We as a law firm have found it complicated to get all of the information.
Yeah. Okay.
We as a law firm have made countless calls to Customs and Border Protection, both at the pre-clearance sites in Europe, it's in Ireland, and the US ports of entry, be it New York. There's a variety of different ports of entry in the United States to clarify what exactly is required. We've worked with a variety of different consular posts about these national interest exemptions. And I can tell you, it's a complicated set of policies and not always being implemented the same way in every place.
Mm-hmm.
I wish I can tell you that there is a one-stop shop to gather all of that information, but there's not. From the national interest exemption point of view, Department of State does publish that on their website. And that's where it's kind of laid out how the exemptions apply. There's only one place to take a look at the proclamations themselves, and that's on the White House website. We pulled them from there, and it is quite complicated to pull it all together. There is not one place to gather all of that information. And what we are finding is that going through this pandemic, the rules change quite a bit.
Seems every week.
It's every week. It's every day sometimes. I wake up to a different landscape every day, and I try to explain it to our clients. And it becomes complicated. I wish I can tell you there's one place to go and get it. There's not. What have you experienced with, what type of organization are you with?
So I'm with actually a Japanese company, Japanese headquartered firm here in Austria. But I asked because, clearly travel, just business travel, has been largely curtailed. However, we are trying to, think about ways to reconnect within Europe and even across between continents. And just, it's just been extraordinarily difficult. We find someone's almost ready to go and then a rule changes. Or what we've also found and heard is that certain immigration authorities may actually, at the port, in Boston versus Washington, D.C., whoever the immigration officer is there, they may actually just differentially interpret information.
100% correct.
And that's just the reality. So our advice has been, and our process has been, that we are ensuring that people bring every piece of paper they possibly have and just keep throwing paper on the desk of the immigration authority.
Yeah, thank you. Those are really good comments and reinforces what I was saying, that different ports of entry are interpreting this very differently. And what we have done, and I think you are saying you're doing the same thing, and it's good advice, is that the foreign national travel with what I like to call an admission packet, a set of documents reflecting evidence to meet whatever criterion they needed to overcome. If there's a national interest exemption and those sets of documents were sent to the consular post and they reviewed those, make sure you carry those to the port of entry, so that when the foreign national is standing in that line and they meet that Customs and Border Protection officer, they have those documents in hand and they're prepared to speak about them. What we're doing is not only preparing the packets for entry to the United States, but of course, going through a discussion with the foreign national of what kind of questions could be asked and how to, why they're asking those questions so that they could be answered correctly. It's really complicated. People get scared doing this. They're fearful, one, of traveling during this crazy healthcare crisis. It's a terrible thing. People worry about it. At the same time, they got to worry about getting admitted. No one wants to sit in the airport and be on a flight going back home. And one of the things that we do as a firm is if we know someone's flying into Logan in Boston, we reach out to the port, and we talk to the folks at CBP, and we try to figure out exactly what's needed locally. You know, a lot of these things are local, so you got to kind of know what's going on. I'm very involved with the American Immigration Lawyers Association. I was chair of Europe, Middle East, and Africa for the association of like 14,000 members. So we have this liaison activity we do with the government. So I'm involved with a lot of liaison activity, and I hear a lot about how the government is handling things, particularly CBP, and I try to translate that over to our clients so that they have the greatest chance of success. But there's days I'm just completely stumped, you know, and I'm calling multiple ports of entry to figure out how is this being handled today. And I can tell you something. A lot of the CBP officers, they're stumped too.
Yeah.
They're getting this information, we're getting it. You know, they're like, I don't know, this is how it gets interpreted. And then sometimes we're faced with listening to what they're saying, and I'm like, no, that's wrong. That's not what it says. And I try not to get into disputes with these folks. You know, I'm not there to be an educator. I'm there just to get information and support my clients. So
thank you for your insight. Really appreciate it.
Sure. Folks, are there other questions? I'm really happy to answer questions as we go along. Yes?
I would like to ask.
Hi, Elizabeth.
I'm a green card holder, and my husband and I have a place in the United States, and I also do some business over there, usually like half a year here and there. However, so when we came back at the end of January here, we got stuck in the lockdown, and I do have a 91-year-old father who does need my help. So I stayed here. I do my business here from Vienna. That all doesn't seem to be a problem. However, I'm a little concerned what will happen to my green card once I try to go back.
Yeah, that's a really good question, and it picks up on some of the things that I spoke about early on in the presentation. You know, a green card holder is a legal permanent resident of the United States. And once you're a legal permanent resident of the United States government takes the position that, of course, you're living in the United States.
Yeah.
Your intent to be in the United States. They don't want you using your green card as a travel document just to, you know, visit the United States, make it easy so you don't need a visa to come to the US.
No, that's not what it is for me.
I know, exactly. It's a green card. You live and work in the US. A lot of people are getting stranded outside the United States because they can't get back in because they're fearful of travel. You know, they don't want to be on an airplane and maybe subject themselves to the virus. So here's how it works. It's always worked this way. It's not specific to COVID. If you're a green card holder and you leave the United States, it's very clear that you can leave the United States for up to 6 months and re-enter as a legal permanent resident. 180 days. You can leave the US, take a trip, visit family, visit friends, maybe go hang out at your vacation home in Vienna, go visit your friends somewhere else in Europe, whatever you're doing. 180 days, no problem. When you come back to the border, welcome back. You come with your green card and you come back in, no problem. So what happens between 181 days and 365 days, that period up to 1 year if you're a green card holder? Well, at that point, there is what's called a rebuttable presumption that you no longer have an intent to reside in the US. So what do I advise my clients? Again, that admission packet that I even spoke about for someone coming as a non-immigrant. What you need to do at that point is to rebut the presumption that you're not residing in the US. Because you've been there for greater than 6 months, you have to prove that it's still your intent that the United States is your home. That's where you reside. So what should you bring with you? Proof that you have a home or you lease a property in the United States.
Yeah.
Proof that you have always filed tax returns in the United States and you filed your most recent tax return as a resident of the United States, not a non-resident return filed in the US. Evidence that you have continued to pay your electric bill, your cable bill, your gas bill, your mortgage, your local taxes, your real estate taxes, all the things that a person living in the United States would normally do. You want to have a stack of evidence that proves that, because the determination of that, the determination of that intent issue is at the time you're entering the United States by the Customs and Border Protection official at the port of entry. So you're flying in from Vienna, connecting in Europe, heading to Boston Logan Airport. When you get to Boston Logan and you're in front of the Customs and Border Protection officer at the port of entry, they're gonna, where have you been?
Right.
I was in Vienna. When did you leave? I left in Christmas 2019. Well, it's Thanksgiving 2020. You've been gone for 9-10 months.
Yeah.
What's going on? What were you doing?
Yeah.
Well, I left and I was planning to be away for 3 months, 4 months to visit with family and friends. Then COVID broke out.
Yeah.
COVID alone is an explanation right now, but I would also have in hand the documentation proving that you still have your home here, you're still paying your bills, you filed your tax return, even up to the extension date, as a resident of the United States, and explain to that officer, it was never my intent to leave, never my intent to leave. Okay, so that sounds complicated yet easy enough, right? You travel with these documents. What happens if you stay greater than 1 year outside the United States? That's where things start to go pretty wrong fast, because at 1 year, that green card is no longer a valid travel document. Okay, so becomes very problematic at that point. So what happens then? My advice is don't let that happen. Try to get back to the United States before you cross the 365-day threshold. Because once that happens, and technically your green card is no longer a valid travel document, you need to file a filing with Department of State through the local embassy or consulate that when you left, you had no intent of abandoning your legal permanent residence in the United States. However, there were unforeseen circumstances that arose after you left that precluded you from coming back to the United States, forcing you to remain outside the United States for greater than 365 days as a legal permanent resident. You don't want to have to do that, really. That becomes complicated. Now because you're waiting for a discretionary determination by the Foreign Service officer to be sure that that's true. That's problematic. And it's expensive. You got to prepare that and do it right. So I would avoid that if you can. So keep the 365-day period in mind if you're a legal permanent resident.
Okay.
Did that answer your question, ma'am?
Thank you very much indeed.
Oh, good.
I'm afraid yes, because the question will be whether I will be able to make the 365 days. But no, it's a very valuable information. Thank you.
Yeah, I will make one other comment that is not applicable to you, but it can be applicable. If someone is leaving the United States as a green card holder, there is a process by which, before leaving, you can file a document advising the government that you, because of whatever the factual circumstance is, you may be outside the United States for greater than 1 year. And you can indicate to them, look, I'm going to be outside the United States for 1 year and 6 months. I have no intent of giving up my legal permanent residence in the United States, but I do know I'm going to be outside the United States for greater than 1 year. basically, it's a request to the government to say, hey, please consider this even before I leave. I want to let you know it's not my intent to abandon my legal permanent residence. So if you have workers in the United States that are on green cards and they need to go back to their home country to care for a relative or to work from there because business circumstances are changing things, it may be worthwhile to file for that before they depart the United States. The reality is they have to get biometrics taken in the United States before they go. So you need to file those applications before they leave and have that in play so that that document can be delivered once they're gone. And it gives one additional step so that when they're coming back in, they show that document as well as these other documents I mentioned to prove that they didn't abandon their legal permanent residence. Here's a key issue. If you're coming back into the United States, you're a legal permanent resident and you're at the border and there is a dispute with the Customs and Border Protection official as to whether you have given up your legal permanent residence by remaining outside the United States for greater than 6 months, do not sign a document that they're going to present to you, a form I-407, saying that you give up your legal permanent residence. I've had too many clients feel pressured at that time. They sign this document and they give up their residence. It's not the thing to do. Let them refer you to the immigration court and sort it out there. Okay, that's a very key matter. So I hope that was that clarified your question, ma'am. Are there any other questions coming from the audience? Okay. Suzanne, how much time do I have today? It's 10 o'clock. I'm sorry, I can't hear you.
Does it work now? Do you hear me?
I hear you now, yes.
Oh, okay. Yeah.
How much time do I have?
How much time would you need?
Well, I maybe another 10 minutes or so to go
Yes,
through.
of course. No problem.
Okay.
We're
Okay, great.
listening with, yeah, perfect.
Thank you. Thank you.
It's a great pleasure to listen to you.
Okay. And great pleasure to have some questions. I appreciate the questions. Okay. Going through some of the non-immigrant visas, going back to that topic, as I indicated early on, you know, there are two steps really to getting a non-immigrant visa. Let's use the L1B visa. That's a intra-company transfer for someone with specialized knowledge. How does that work? Well, two phases. The employer needs to file a petition with USCIS to get that petition approved. Then the individual needs to actually apply for the visa before a US consular post. So now this two-step process. What has COVID done to limit that? Well, USCIS, big delays. There used to be, well, there always has been something called premium processing for these petitions. These petitions, you pay an extra amount of money and the government processes within a shorter period of time. Once COVID hit, premium processing was canceled. Then it came back. It's back now. However, due to the funding issues with USCIS, they've raised the fee to get a fast determination from $1,400 to $2,500. If you're moving 100 employees a year, that's a big number. Some of my clients are suffering the consequences of the premium processing right now. So yes, there is premium processing. Do I think that's going to be shut down? I don't know where things are going to go with COVID, but keep that in your front burner if you're moving a lot of people around, because premium processing is key. Otherwise, you're waiting many, many months before a petition gets approved. And you're waiting many more months because of COVID, because of, you know, many of the nice people that work at USCIS are working at home, and that creates longer wait periods. Then, okay, now the employer has got that petition approved, premium processing or not, it's approved. The foreign national needs to go for an interview. Well, during the early days of COVID, consular posts had closed. There was no door to go knock on because they were closed. The Foreign Service officers were restricted in the work that they were doing, and just emergency situations were being dealt with. They closed, then they reopened. I can tell you that, so many of the consular posts around the world are operating at a limited capacity due to the COVID crisis, and that's certainly understandable. Then the presidential proclamation. So no new visas being issued unless you could meet one of the exemptions to the presidential proclamation. So then not only do you have to make this appointment for the person and find a day that's available, but you also have to file the appropriate documents to not only prove that the person qualifies for the L1, but also that they meet the criterion of the national interest exemption. So even more time goes into that. Then they have to go for this interview. They have to get to that date and time, go for that interview, deal with all the COVID restrictions. There's less and less people on a daily basis, so the wait period is a lot longer. So what's the point of all of this? Me explaining this? It's going to take a long time. What used to be people calling me and saying, hey, we have to move our specialized knowledge worker from our company in Austria to Houston, Texas, ASAP. My comment that, hey, we'll just get everything ready in 7 to 14 days, file the petition, seek premium processing for a 15-day adjudication, and then get them in for an interview probably within 72 hours. That has all changed. What went from that compressed schedule is now a big, long process of getting people into the United States. It takes a lot of time. Plan ahead if you're moving your employees. It's not going to happen overnight. Even if they're coming as visitors to the United States. I gave you that example of my clients from Ireland coming over to supervise some of the work that they're doing here. How to get national interest exemptions out of Dublin took a long time. Planning on all the COVID requirements for them to come into the United States. Interviews, it's been a mess just to make that happen. And we're dealing with endless number of cases like that where the time frames are so long. It takes a long time to accomplish all of this. And keep in mind, once they enter, state law requires quarantine periods, production of tests, all of the things to be able to enter the state and lawfully do the activities. Most states, it's a 15-day quarantine. So we have some clients that have to be on the work site, not 14 days after entering, but a couple days after entering. PCR tests before they enter, the day before, get them, present them. The soon as they get into the state, look at the state regulations, work with the CDC, work with the Department of Health to make sure that they can do their activities in the state. Some other non-immigrant visas that we often deal with are the H-1B visas, specialty occupation. Countless software engineers we represent, medical residents doing training in the United States, architect, people that are coming that have the minimum of a bachelor's degree for entry into the field. Limited number of visas available per year, 65,000. If the foreign national has a US master's degree, 20,000 more. Therefore, 85,000 visas in total available. A lot more demand for the visas than there is supply. When you're looking at 85,000 visas, there's probably 250,000 people applying for those visas. The United States government has created a lottery system by which those who want an H-1B have to go into a lottery and get selected before their case can even be filed. The lottery is going to open up in 2021 for the first day of filing, April 1, for a first day of employment, October 1. There's been a whole lot of discussion about how the new lottery is going to come into play, different wages that have to be determined by Department of Labor. The wages are increasing for someone to enter as an H-1B. Before your company decides to sponsor an H-1B, figure out what the prevailing wage is by Department of Labor, because you will need to pay that person the prevailing wage or the higher of the actual wage in the company for someone with the same job, same geographic area, same experience. There has been a change in the prevailing wage determination. And for H-1Bs, it's going to be pretty critical. You may be spending a lot more on wages to have someone enter on an H-1B, and it's being litigated. I can't tell you how many of the policies that have come out during the last 4 years are being litigated in court. So part of my waking up in the morning to a new landscape is waking up to the new litigation and the determinations made in the Northern District of California compared to what's happening in, the first district on the East Coast, how that gets applied, how federal law gets applied across the jurisdictions. It's mind-boggling, especially for my clients that are not familiar with the way US law works and the Supreme Court challenges and the ongoing issues that arise from that. It's quite complicated. And we find ourselves doing much like I'm doing today in educating people about what's going on and how all of this works so that their companies are the least impacted, or at least they know what to expect. Please, if you take nothing away from this, as a organization that moves people to the United States to work, plan ahead, give enough time for all of this to work out, and understand the limitations of all of this before you get involved. It's 100% doable. As I said early on in one of the slides, are the doors still open? But you got to know how to open the doors here. And then there's doors behind doors that you have to walk through to make all of this work. I work with a lot of investors from Austria, those that are coming to the United States to run a business. They're making a substantial investment, coming here to run their business, bringing employees from Austria that are Austrian to work with them in a essential needs capacity or executive capacity. Is that process still working? Yes. The good folks at the US consular section at the US Embassy in Vienna are still adjudicating these. They've been adjudicating these throughout. They do great work. They get done quickly compared to other posts. Things are still working. Those folks are exempt under the national interest exemption. They get their interviews, they get their visa. The visas are affixed with an annotation saying that they're exempt. They're able to travel to the United States and run their business. The family members of the investors can come to the United States as well. So if the investor was in the United States in February, shut down March, spouse and children in Austria, he can still come to the United States. There's an exemption. They have to get interviewed, but there's an exemption. And we've moved family members to the United States to reunite them with their family throughout this pandemic. You're very fortunate, again, to be within the jurisdiction of the US Embassy in Austria compared to doing this maybe in a country where there's a huge volume, be it China or India or Philippines, where things are a lot harder to do it than in Austria. Austria had done historically third country national processing. So if you had someone from China that happened to be in Austria and needed to go for a visa interview, the post would accept them. These days that has stopped. The jurisdiction is really for those that live within the jurisdiction now. So third country national processing, as best as I know, has slowed down or is not available, excuse me, at this time. But still, wait times are rather good in Austria right now. I've spoken about the visitor visa to the United States, another non-immigrant visa, one that we deal with quite a bit. Fortunately, Austrians are part of the visa waiver program. No need to apply for a visa if they wish to enter the United States as visitors for pleasure or visitors for business for up to 90 days. If they're going to be in the United States greater than 90 days, up to 6 months, 180 days, you need to apply for a visa foil to be affixed into the passport. Even though you might have a visa, you still can't enter the United States right now due to the presidential proclamation barring the entry of those that were in the Schengen territory within the last 15 days. So you have to get a national interest exemption if you're seeking entry to the United States as a business visitor to the US. Over the last months, I've had people that chose to go from Austria to a non-Schengen territory, or a country that is not part of the other 4 proclamations that are geographic based, maybe go spend some time in Mexico before seeking entry to the US. So Vienna, Mexico City for greater than 15 days, then entry into, say, Atlanta. Technically, a reading of the law suggests that if you spent the last 15 days in Mexico, you weren't in the Schengen territory, therefore CBP was admitting them to the United States. The conversation that I had with endless number of clients that sought that route was that what are things like in Mexico from a healthcare perspective, and how is healthcare going to be delivered if you're there as a visitor and God forbid you get COVID? You know, how do you deal with those issues? So I've had people bump themselves all over the world to be able to enter the United States to get back to a business or reunite. But I think the safer course is seeking an exemption than having to go spend time in a third country. So let me move on a little bit and keep this to the additional 10 minutes that I requested. I've listed on this slide the countries that are part of the visa waiver program. What that means exactly is that citizens of these countries don't need to apply for a physical visa foil to be affixed into their passport. They need to just register with the ESTA system, get an ESTA registration, carry that with their passport if issued from one of these countries, to be able to enter the United States as visitors for pleasure or visitors for business. Keep in mind the presidential proclamation for those in the Schengen territory. The stay under the visa waiver program is limited to 90 days, no extension on top of the 90 days. If you got stuck in the United States due to COVID, there was a process called satisfactory departure. I've done countless of these since March. Because there's no extension of the 90 days, you have to get a very special determination made by Customs and Border Protection at the local port of entry or the Customs and Border Protection field office in a local city, wherein you request and provide documentation that there is no way for you to get back to your home country and you wish to remain in the United States for a short period beyond the 90 days. And I've had Customs and Border Protection give me some of the hardest time to prove that the person couldn't get back to their home country. I have to provide documentation from the travel industry showing that there are no flights available with any connections going through a variety of different countries to get them back. And we've been successful with all of them, but a lot of documentation needs to be submitted to prove that. And then the government will issue a short extension for those under the visa waiver program. If the person was here on a visa, where they're here on a visitor visa, B1, B2, we simply file for extensions, which gives them up to 6 months during the adjudication process to remain in the US. So there are some options if folks are stranded in the United States. I spoke about ESTA. I spoke about the H-1B visa. That's just one of the H visas. There's a variety of new visas, additional H visas that are available to foreign nationals coming in for very specific work in the US, be it temporary agricultural work or non-agricultural labor in the US. I spoke a little bit about the L visa. The L visa is for intracompany transfer. Basically, you have a foreign company, a US company that has a qualifying relationship, subsidiary, parent company, etc. You can move executives or specialized knowledge workers between the two companies for a defined period of either 5 years or 7 years. We do a lot of L visas. During this administration, it's been a little harder getting L1B visas due to the policies that come out and a variety of different issues, but still very doable. Still need an exemption because there's a bar on L's, H's, and J visas into the United States. So you have to get an exemption if the foreign national wants to come in during the proclamation validity period. So still an option, but requires some additional steps these days. The E visa, this is really an investment visa. If there's a treaty between the United States and the foreign country, which there is with Austria, An Austrian citizen can make an investment into a business, develop a business plan, show that it's a substantial investment, show that they will be working in the US as an executive or manager, and as a citizen of Austria, be able to come to the United States to run their business. A very, very, very good option for individuals seeking to make an investment here and live in the United States while they're running their business. They could then bring their Austrian employees if they fall within essential capacity workers with the e-visa. We do a lot of those, particularly for our Austrian clients. O visas are for those of extraordinary ability. You have to prove that they've really risen to the top of their field. We do these for those that are in the sciences. We represent one of the top scientists for animal feed formulation in the world. He's here on an O visa. We represent some top level, globally recognized athletes that come on O visas, and even those that are below that level, but we can still prove the elements. This is a way to bring folks to the United States temporarily. Again, these are all non-immigrant visas. I won't talk too much about Canada and Mexico, but there are specific visas for those that are citizens of those nations. Going back to wait times, I just pulled a screen capture of a slide that shows the processing time for a non-immigrant visa in Vienna compared to a non-immigrant visa in Moscow. 300-day wait period compared to a 4-day wait period. Carefully, well, there's not much choosing these days because it's all limited by jurisdiction, and COVID has changed third country national processing, but big difference. Plan ahead on timing. Immigrating. This is the process by which someone gets a green card. We spoke about that a little bit earlier. Green cards. Most people in the United States as legal permanent residents are here based upon a familial sponsorship. They're getting sponsored by their US citizen spouse, parent, child, legal permanent resident spouse. These are all ways for a foreign national to get a green card. What if you as a company in the United States want to sponsor someone for a green card? Well, you have to do something very specific. You have to test the US job market to conclude that there is not a US person available to fill that spot, and that you have to then offer that job to that foreign national because they're minimally qualified. You start with Department of Labor. Takes them a long time to adjudicate that. You file all the necessary documents, they go through that process. Then you as an employer file with Department of Homeland Security. You have to wait another period of time before they make a determination. Then the foreign national can apply for that green card. Depending upon what country they're from, for them to file for the green card may be as soon as a few months compared to many, many years before they can actually apply for that green card. And that's all based upon the fact that only 140,000 foreign nationals can get a green card per year based upon these employment categories. That has not changed for many years, that 140,000. Because that hasn't changed, there's been a backlog for the countries for which there's more and more people that want to come to the United States. Think India, China, places that are highly populated. So the backlog is very long. You've probably heard that Indian nationals may be waiting upwards of 5-10 years before they could actually get that green card. So part of what we do is create strategy so that that individual can work in the United States under a non-immigrant visa while this green card process is ongoing. And we just kind of create a continuity of lawful status in the United States so that they can be here as a non-immigrant and then move into a green card process. These are the categories of employment-based green cards, ranging from those of extraordinary ability down to those that make a very significant investment in the United States, but most fall into the second and third category, those with advanced degrees or a bachelor's degree and 5 years experience, or just someone with a bachelor's degree coming into the United States. Each have different wait periods that I won't get into now. It's beyond the scope of this discussion. Okay, family-based immigration, I spoke about it. There are a variety of different categories for US persons to sponsor foreign national coming into the United States for a green card. The easiest route is a United States citizen, spouse, parent, or child sponsoring their foreign national, the least wait period. The longest wait period is a US citizen sibling sponsoring their foreign national sibling. The wait period, depending upon the country, can be upwards of 15 years for the Philippines. You will be waiting before that person could come into the United States. So the wait period is quite long for siblings. But if you're a United States citizen, spouse, parent, or child of a foreign national, the wait period is much shorter. We bring folks over within, a year to shortly over for that immediate relative category. Last but not least, naturalization, the process of becoming a US citizen for those that were not born in the United States or not born abroad to parents that are US citizens abroad. Naturalization occurs in two different categories: the spouse of a US citizen or everyone else. A spouse of a US citizen, once they become a green card holder, they have to wait 3 years before they can naturalize. If someone is here on a green card based upon employment, they have to wait 5 years since the date they got their green card to naturalize. Once they naturalize, the person's a United States citizen, they take an oath of allegiance to the United States, and they have all the rights and benefits of a US born citizen. So that's naturalization. In closing, a new presidential administration. Joe Biden has taken a initial position that I think is more pro-immigrant than the current administration. His 25-page immigration policies that are set forth on his website talk about bringing a more just system to the United States for administration of our immigration laws, talks about focusing on a revamping of the system, comprehensive immigration reform, a kinder, gentler way of treating those coming to the United States for humanitarian purposes, and a focus on the need of business in the United States as it ties into visa policy. I anxiously await to see how this all plays out. I'm interested to see how our Congress sorts this out, depending upon how things get sorted out post-election and the majority within the House and the Senate, and how that's all going to play. During the Obama administration, they sought to do comprehensive immigration reform, but as many of you will remember, it did not work out in Congress. I hope for some positive days to come where there will be immigration reform that talks to a system that really meets the needs of the United States, particularly for my business clients. And I hope that we soon have a vaccine so that the COVID restrictions are no longer in play. Until then, I think we're going to continue to face some of these healthcare related issues. And I think a lot of them are just to make sure that people are entering that are healthy. So the point to take away: plan ahead when moving people to the United States. Understand that things are changing daily, and understand that there's folks like me that are available to advise on a national basis to work through this system. The doors remain open, but you have to know how to walk through these doors to get it done successfully and as quickly as it can be done under normal circumstances. So with that said, for those that remain on the call, if there's any questions, I'm happy to answer them. I, again, really appreciate the time to chat with everyone. I hope this was informative. And I look forward to seeing everyone in Vienna and not by way of Zoom on the days when I can do this in person again. I'm often in Vienna with normal travel about every 6 to 8 weeks for my practice, and meet with my clients in Austria face to face, and look forward to meeting with anyone that's interested going forward. Any questions? either I did a real good job or people are shy to ask questions.
Thank you for a very informative presentation.
Oh,
Extremely helpful, and I think the plan ahead point is well taken, especially I work in the pharmaceutical biotech industry, and your point about the vaccine, for everyone to get access, it will take time. And so it's really important that
exactly.
we adjust to this new normal, which is from a business perspective, you can't just jump on an airplane and go somewhere. It's
right.
really the multiplicity of immigration plus the health requirements.
It's unbelievably complicated,
Yeah.
because
So thank you.
have been working with folks and managing that. The ones that can put off the travel, do it. But there's circumstances where people just must travel.
Yeah.
And you have to somehow navigate through this. So you're very welcome. My pleasure to chat today.
Yes, so let me thank you so much for giving us such interesting insights and much useful information. And I thank all of you for joining us today. Give me just 1 minute. I just want to announce our next events. Next week on November 17th, we have a webinar with Magister Gloger. He is the CEO of Boris Gloger Professional, and David Gazelle, Head of Learning Development, Erste Bank. And they are talking about creating a new work culture, how a small initiative changed perception. On November 27th, our last AmCham talks in this year with Philipp Madatana. He's also called the Kanzlermacher, and he's talking about Begeistern, Wachsen, Großes Bewegen, die neuen Gesetze für Erfolg und Freiheit als Unternehmer. Sounds also very interesting. And last but not least, on December 10th, an interactive webinar with Jean-Pierre Kalanian from AP Consulting. Also a really interesting topic, adapting to change or changing to adapt. Yes, so I hope you will take your time and join us again. Thank you very much to all of you. Thank you, Mr. Savatteri. It was really an honor to have you as a guest speaker. And take care, stay healthy. And I have to close the conference now. All the best and goodbye. See you next time.
Everyone, thank you.
Bye-bye.
Thank you. Goodbye.